Welcome to the thank you. Welcome to the Committee on Rulemaking, and today we'll be focusing on a report on regulatory enforcement manuals, report and recommendation on the two. But as a start to the meeting, we'll have Alexandra call the rolls.
Thank you so much. And I am Alexandra Saibo. For those of you who don't know me, I am very pleased to be ACUS staff counsel for this project. It's been a wonderful experience. I'm going to go ahead and get started with calling two rolls. The first roll call will be for members of the Committee on Rulemaking. If you could please go ahead and unmute yourself, let us know that you're here, and then please remute yourself once we've got you down for both attendance and checking microphone purposes. So we will go ahead and get started, and we start off with our wonderful chairman, Mr. Bertrand Ross.
I am here.
Thank you so much. And next up, I have Emily Bremer.
Here.
Thank you, Emily. Nice to see you. Next up, Peter Constantine.
Hi, here. Good afternoon.
Good afternoon. Thank you, Peter. Kirti Datla. Next up, Thomas Johnson.
Here.
Wonderful. Thank you. And next up, Nina Mendelson. Might be running late. Okay, thank you. Next up, Elena Ness. I think I see you.
Yes, I'm here. Thank you.
Wonderful. Thank you. Next up, Richard Pierce.
Here.
Wonderful. Thank you. Nice to see you. And David Pritzker is up next.
I'm here.
Thank you very much, David. Next up, Lon Smith.
Here.
Thank you very much, Lon. Kevin Stack is up next.
Hello, here until I have to jump off to teach.
Wonderful. Thank you so much, Kevin. Next up, Miriam Vincent. And then Adam White.
Here, sorry I'm late.
Thank you very much, Adam. Okay, are there any members of the Committee on Rulemaking who did not hear their name at this time?
Hi, Nina Mendelson. I was
hi, Nina.
joining.
Thank you so much. Nice to see you. All right. Any other members of the Committee on Rulemaking who did not hear their names? Okay, very good. I will move on to the second roll call, which is members of the Administrative Conference who are not on this particular committee and alternates of such members. And we start here with our wonderful Williams Fellow, Jordan Perkins, our project consultant.
Here.
Thank you so much. And next up, I have Bill Funk.
I'm here, but I'll have to leave in an hour and a half. Thank you.
No problem. Thank you so much for joining us, Bill. And then next up, I have James Giaraputo, the alternate for OSHA. Hopefully I pronounced your last name correctly. I see you're here, James, but I couldn't hear anything from you. Are there any other members of the Administrative Conference or any other alternates who are present at this time who did not hear their name called?
Miriam Vincent, I just joined.
Thank you so much, Miriam. It's nice to see you. Any other members of the Administrative Conference or alternates of such members? All right, very good. And I will happily at this time turn it over to ACUS Chairman Andy Foyce for his opening remarks. Thank you, Andy.
Thank you, Alexandra. And let me say that as chair of the Administrative Conference and on behalf of all of us at ACUS, welcome to the first fall meeting of the Rulemaking Committee in 2022. Thank you to all of you for being here, members of the committee and other ACUS members. And if we have any public members, welcome to you. Let me start by forwarding a very special thank you to Alexandra for all of her work on setting up this meeting and as project staff counsel, and to other staff at ACUS who also worked on things. A very special thank you to our committee chairperson, Bertrand Ross, for agreeing to take on this responsibility. And this is his his first meeting. So we look forward to sharing that with him and thank him for his service. Also, a very special thank you to the project consultant, our former, now former, our Williams Fellow, Jordan Perkins. Jordan, I think it was a very insightful and interestingly handled treatment of an important topic. So I look forward to your presentation and to the committee discussion. So with that, let me turn things over to Bertrand.
Thank you so much, Chairman Forrest, and thanks for joining us at this meeting and sharing those opening remarks with us. Now, just a few meeting notes and overview for our meeting. Please note that only ACUS members, which includes government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee and their designated alternates, have full speaking privileges. To avoid background noise, though, I'd ask that you keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. Please then remute yourself when you're done. I'd also ask that ACUS members and their designated alternates use the webcam to facilitate conversations. And I appreciate all of you that are on webcam right now. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and we'll presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you're done speaking. For all participants, please use the chat feature only to indicate that you'd like to speak, or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Only members of the Rulemaking Committee, including government members and designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee. We have a list of committee members in case you're unsure. So let me turn it over to Jordan Perkins, who will present on his report with respect to regulatory enforcement manuals. He'll provide an overview of the report, including some of the research that underpins the bases for the recommendations and some comments on the suggested recommendations. Jordan?
Thank you very much. I will try to keep my comments brief. The empirical studies behind this report was an attempt to gain a fuller understanding of agency enforcement practices, and particularly of the staff manuals and related guidance documents, which serve to control the activities of line staff involved in regulatory enforcement. I was particularly interested in the extent to which the contents of enforcement manuals are of interest to the general public, and whether these materials are readily available, either through public availability of the manuals themselves, or through other forms of publicly available regulatory guidance. Regulatory enforcement, as you know, encompasses a large range of activities, audits, site inspections, investigations, any kind of negotiations with the regulated entity over remediating violations discovered before the adjudicatory stage. The report does not cover adjudicatory activities, either those of prosecutors or the adjudicators themselves, whether before ALJs or federal courts. So in order to understand how agencies use enforcement manuals and related guidance documents, I began with an empirical study of every available enforcement manual I could locate on agency websites and elsewhere, which yielded a data set of about 15 publicly available manuals. Enforcement manuals generally contain a range of information about the sub-entity within the agency responsible for preparing them, on the agency's overall regulatory mission, on the triggering conditions for enforcement actions, procedures used for undertaking audits, inspections, and related activities, the standards for assessing the severity level of any particular violation, and the agency's powers to take corrective actions. The information was valuable in getting a general understanding of the enforcement practices of these agencies and how enforcement manuals and other guidance documents shape the behavior of enforcement staff. I also found that enforcement manuals often contain a range of other materials, particularly in the public, potentially in the public interest, such as information concerning when the agency should put out press releases or other public information about the enforcement matters, how members of the public can bring complaints or tips to the agency's understanding of which materials obtained from regulated entities are to be treated as confidential, and so forth. This first stage of the research provided much of the understanding of how agencies use enforcement manuals and the extent to which there exists a public interest in them. I also spoke with attorneys at the enforcement divisions and general counsel's offices of a half dozen agencies about their enforcement procedures. Some of these agencies agencies had publicly available manuals, and I was able to discuss with these agencies how the manuals shape enforcement behavior in the real world, and some agencies did not. With the second group of agencies, one was a young agency, which was in the process of developing its first enforcement manual, and two had non-public manuals. Those agencies choose to instead use other forms of regulatory guidance to inform the public and regulated entities. My report also discusses some of the legal issues related to the public availability of enforcement manuals, particularly the circumstances in which agencies may be required to make their manuals available under the Freedom of Information Act. I found that while there may be circumstances in which agencies must make some of the contents of their manuals publicly available, there appears to be a fairly large realm of agency discretion to publish or not publish staff manuals. Many of my recommendations were thus concerned with weighing the costs and benefits of public availability. As my report emphasizes, the assessment of costs and benefits will differ from agency to agency, given the diverse missions and practices of federal agencies. On the cost side, the agency has legitimate concerns in not tipping its hands in ways that might allow bad actors to evade detection of regulatory violations. And the FOIA case law respects the agency's strong interest in protecting the secrecy of investigative techniques. There are also significant costs involved in ensuring that enforcement manuals are kept up to date. Deciding to maintain a centralized manual can take a great deal of time and energy away from the agency's attorneys, and agencies may decide it's not worth the expense compared to using a set of staff directives or other more basic guidance documents. And even if the agency decides to maintain a centralized manual, there are additional costs in redacting non-public information and ensuring that it's up to date and clear in a way which can be used by by outside entities. Balanced against these costs are a range of benefits, primarily related to the transparency that enforcement manuals can bring to agency enforcement activity. My report stresses that there are multiple distinct publics, each with different interests and enhanced understanding of agency enforcement policies and practices. As a few examples, regulated entities themselves are interested in how sensitive information handed over in enforcement proceedings will be protected by the agency. Workers injured on the job might want to know how to bring complaints to the agency and the extent to which the complaints will be kept confidential. Local communities that are protected by environmental regulations or public safety regulations may wish to know how to bring relevant information to the agency's attention, and when and how the agency will bring information it discovered in its enforcement proceedings to the public. My report stresses that each agency should be sensitive to the range of these interests and the strength of each group's interest within the broader context of the agency's overall regulatory mission and goals. I stress the importance of public availability as a function of the extent to which all relevant information is provided through other means, such as policy statements, white papers, publicly available memoranda from agency officials, and the like. You have for your consideration a set of recommendations based in part on my report. Some relate to the threshold question of when agencies should develop centralized enforcement manuals to collect enforcement-related guidance into a single authoritative source. Some relate to ensuring that the enforcement manual is kept accurate and up to date, a requirement of the manuals to be useful on an ongoing basis to either agency staff or outside entities. Other recommendations deal with the materials that an agency developed or revising in its enforcement manual may wish to include, based in part on my survey of existing enforcement manuals. Other components of the draft recommendation deal with the public availability of enforcement manuals and the extent to which the agency may wish to seek feedback from regulated entities or the general public before promulgating or significantly revising its enforcement manual. My report both discusses these matters in some detail and provides references to past ACUS recommendations and reports, which deal with similar matters of public availability and the solicitation of feedback from the public in other contexts. With that, I'll hand things back to Bertrand. Thank you.
Thank you so much, Jordan. So in terms of how we'll run the meeting, in terms of examining or deliberating on the recommendation in the report, I'll first ask for general comments on the report and the recommendations that aren't necessarily specific to any particular recommendations. And then we'll jump into the recommendations one by one, and then we'll return at the end to the preface and deliberate about the preface and offer any suggestions for revisions or development, etc. I will say that we've gotten one comment from Richard Pierce with respect to recommendation 2B that we'll share and deliberate upon when we get to that particular recommendation. I intend to rely extensively on Jordan as someone who will respond to thoughts and feedback on particular recommendations and proposed changes and see what he has to say as a starting point. And then we'll open up the deliberations more broadly to the rest of the committee going forward. So let me just kind of start by asking if there are any general comments on the report and recommendations that anyone wants to share. Yes, Emily.
Hi, and thanks, Jordan, for this great report. One question I had is whether you considered talking to any folks who use enforcement materials outside of agencies. I mean, I understand that there would be PRA requirements and limitations on such interviews, but I was a little surprised that there weren't some conversations. I mean, the agency officials, I'm sure, have a good sense of how their manuals are used, but I thought that some of that perspective, which seemed to be important in informing the recommendations, might be beneficial.
So when we were planning the interviews, we considered interviewing people outside the agencies. We ended up not doing that. I did find that agency officials we spoke with tended to think that they had very close connections to sort of the specialized bars that they dealt with most commonly from regulated entities and also with members of the public. So it seemed that they had a pretty good sense of how the manuals were used both by the general public and by regulated entities. And we could have done more interviews with outside entities for this project, but we chose not to.
Any other questions or comments about the report more generally? Okay. So I'll have Alexandra kind of share the screen with the recommendations so that we can start to examine them one by one. Thank you, Alexandra. Okay. And I'm assuming that everyone can see those unless you raise your hand to tell me otherwise.
Let me know
Okay,
if
well,
I need to increase the font size at all. Thank you.
yeah. Okay, is everybody okay? Okay. Let's start with the first recommendation. And I guess this only has one part to it. Is that right? Yes. Okay. The first recommendation. Does anyone have comments or suggestions with respect to the first recommendation? Make sure everybody has a chance to read it before moving on. Okay, why don't we scroll down then to the second recommendation, and we'll just kind of take this letter by letter. Any comments or suggestions with respect to 2A? Well, then let's turn to 2B and just give Richard Pierce an opportunity. Oh, I'm sorry, Adam. Yes, is this with respect to 2A?
It is.
Thank you.
And I'm sorry, I was a little slow on the trigger with
No worries.
the raised hand. I'm just curious about the very, very last subclause in that one, the manual, the part about the disclaimer. I'm just curious where that came from and how the drafter thought about phrasing it there, because it's an interesting caveat.
Jordan?
So I'm not sure that came from my report. So other ACUS staff may wish to speak to that one.
I will weigh in if you'd like, Jordan. I know where that came from. So at least the idea here is that often enforcement manuals are issued by enforcement bureaus. They are often not issued by agency heads themselves, and in some cases may not bind agency heads. So this doesn't take a stance as to whether that's an appropriate process or not. Basically says that if this reflects the opinion of an enforcement official, for example, and not the agency head, at least make that clear in the disclaimer.
That's great. Thank you.
Any other comments, suggestions with respect to 2A? Okay, let's move on to 2B then and have ACUS committee member Richard Pierce or David Pritzker. I'm sorry. Is this with respect to 2A?
My comment pertains to 2A.
Okay.
Before my retirement from ACUS staff, I had the opportunity to spend half a year in the ombudsman's office of one of the regulatory agencies. And one of the issues that came up was not about an enforcement manual, but about agency guidance. And there were people from the general public among the regulated industries that were asking whether they could rely on the guidance, because evidently they had experienced situations where they had relied on the guidance and then the actual enforcement was kind of different. So that's my preface for asking the question, which is to what extent are these documents, could they be regarded as guidance on enforcement, and to what extent, if any, where these are made available to the public, can the public rely on them as guidance?
Jordan, do you have any thoughts to lead us off?
Yeah, so this came up in a couple of ways, primarily in the legal research on the FOIA issues. There are ways that enforcement manuals can be binding. So there's case law where the enforcement manual sort of promulgates for the first time some kind of binding standard. There's old case law from the 1990s on the Federal Aviation Administration, where they basically promulgated for the first time a mandatory minimum sentence for revocations of pilots' licenses in their enforcement manual. And this was treated as sort of a binding by the court as a binding standard that should have been promulgated through notice and comment, and therefore it could not be applied against the entity in that case. So there are situations in which the agency does put something in enforcement manuals. The court will say, actually, this is a binding standard and the agency cannot rely on it unless it goes through notice and comment. Another way this sometimes occurs is there is case law. I remember a case with the Nuclear Regulatory Commission in which the agency is seeking our deference for an interpretation of its regulation. And the court looks at the enforcement manual and says, actually, what you're advancing for this court is sort of it's in contradiction to what the enforcement manual says. So the court will rely on the enforcement manual and refusing to grant the agency our deference for a contrary interpretation of law. So there are ways, I mean, I think generally these are guidance documents, they're not binding, but there are ways in which it can, in a concrete situation, become an issue of whether this can be taken as binding or not in court.
So should there be something in the recommendation addressing those concerns?
Jordan?
So my understanding of what we were doing with Jeremy and when he discussed 2A is sort of rested implicit in that, the manual does not necessarily reflect the views of other agency officials, is sort of the statement in the manual where it says this is not binding, this is not, these are not rules. No one, including the agency officials themselves, can rely on this. But whether it should be made more explicit, I guess, to the to your judgment in the committee.
I think one option might also be in C, where it talks about describing the manual's legal effect. So perhaps that's a useful location for it as well.
Nina.
Yeah, hi, thank you. I think David's raising an excellent point, and I'm wondering if folks have coordinated this document, this recommendation, with ACUS's previous work on guidance documents, because it seems to me that whatever we recommend here ought to be consistent with whatever disclaimer recommendations we made in that document.
Jordan, are you aware of the disclaimer recommendation we made in the guidance document?
So I referenced those in my report, and I made an effort to keep my recommendations consistent with the guidance. The staff at ACUS involved in drafting the recommendation itself might want to speak to this as well.
Sure. Yes, we did carefully go through those recommendations. We were also careful, at least in creating a first draft of this, not to simply restate the recommendations. I mean, I think 2017-5 is relevant here as well. We did include a paragraph in the preamble which says this builds on previous guidance recommendations, which hopefully cues readers in to look at those. But if any points bear reiteration in this recommendation, that's certainly doable.
David, is that responsive to your question? Do you have recommendations for amended language, or do you want to wait to our discussion of 2C?
I don't have a specific recommendation, but if others had the same concern, maybe adding a couple of words at the end of 2Cs and legal effect, including the extent to which the content of the enforcement manual may be relied upon, something like that.
Okay, so we'll, thanks Alexandra for putting that in there, and we could discuss it further when we get to 2C to see if there's any additional change in language or if people agree with that change in language. Any other comments on 2A? Yes, Nina. Sorry, I saw a thumb up. I didn't know if that was agreeing or a hand. Sorry. Yes, Nina. I think you're
I probably did use the wrong symbol, so sorry
Yeah.
for that.
No
I'm just
worries.
looking quickly at recommendation 2017-5, and it does seem like recommendation 3 might be a useful recommendations 3 and 3 might be a useful cross reference here. I don't see any reason why we shouldn't use the same where applicable, where it isn't always, I recognize, why we shouldn't use relevant language that we already drafted for guidance documents here. I think that would just avoid confusion rather than trying to, reinvent the wheel.
And so, so perhaps using the parallel language from the ACUS guidance document recommendation in this particular report, and that would fall under 2A. Is that right, Nina?
Well, 2A seems relevant because that's where it's reserving the ability of the agency to act differently from what's stated in the enforcement manual. So 2A seems relevant to me.
Okay. So we'll have the staff, look to the guidance document from 2017. Is that correct? Or 2018, 2017? And sorry, Nina, cut you off.
Yep, 2017-5.
2017-5. Okay. Thank you.
Before we leave this, I would just note that A it addresses the agency employees. And I was thinking in my comments about information communicated to the regulated public.
Right. So to the extent identify whose name it might be. You should consider okay, and so the question is with respect to 2A, going back to the audience for 2A, is that directed towards agency officials or to the regulated entity or both? Should we understand it, Jordan or Jeremy?
Personally, I could imagine it being useful in both cases. So,
okay. So that would be appropriate place to put that disclaimer to the extent it's going to both. Okay. Any other comments or suggestions with respect to 2A? We'll make those amendments. Yes, Kevin.
I guess maybe I've lost a little track of exactly what's going on here, but I was convinced by Jeremy's suggestion that 2C was the right place to put this kind of qualification in. I don't know how much to put in it. I think it's hard. I worry a little bit about David Pritzker's suggestion that's in there because legal effect there's a lot of different variables and reliance is one of them. And so I kind of worry about putting too much in here, but I guess maybe I'm making 2 points. I think that these qualifications about the legal effect of the guidance, which is where David Pritzker got us going, legal effect of these enforcement manuals, the extent to which what kinds of guidance there are. I feel like 2C is the place that's most appropriately lodged, whereas 2A is really about who within the agency this is responsible for. That's the first point. The second point is, I guess it makes me a little nervous. Maybe we can refer to, it makes sense, as Nina's suggestion, to refer to language that the ACUS has already adopted on the qualifications and sort of boilerplate on guidance. I worry a little bit about the addition we have in there now, just because I think there's a lot of complicated issues here.
Okay. So I mean, just speaking for myself now, I agree that assessing reliance and binding effect is better placed in 2C. And perhaps, we can either modify or add the disclaimer to 2C as opposed to 2A. But I wanted to make sure that there is broad agreement. If there's any objections to that, ACUS and the staff will make those changes and perhaps bring in the language of the 2017-5 report to make sure it's in accordance with prior recommendations and that we're not adding, ambiguity or complexity to the actual recommendation or problems from the recommendation. But does anybody object to that?
This is not an objection, but just a suggestion based on something that was just said. Change including in my proposed language for C to the word and.
Okay, so a legal effect and the extent.
Yeah, so that's not taken as a modifier.
Got it.
Limitation on legal effect.
Got it. Got it. Okay. Thank you, David. Any other comments or objections? We'll get the new language for the next edition and we could explore or deliberate about it then, but I want to make sure that everyone is on board with, at least the efforts to make the amendment. Okay, so without further comment, we'll move on to 2B and at long last turn to Richard Pierce to the language for his amendment is in there. Okay, so Nina, you want to raise that point to the broader committee with respect to A. Her point is that perhaps we should put A and C next to each other, so that perhaps moving C to B and then moving B to C as a way to connect those 2 points better to each other. And I'll let that sit with you for a minute or two to see if there are any comments before moving on. Okay, so let's go back to what was originally 2B, but now might be 2C, and to Richard Pierce's amendment, and to see if he has any comments or he wants to elaborate on the reasons for the change that he proposes.
Thanks, Bertrell. I think the rationale is pretty simple. I just think every agency should acknowledge the reality. There's always a risk that somebody involved in the enforcement process will overstep boundaries, and that every agency should have some mechanism in place, at least in the form of a person or an office to whom you can complain when you think that's happening. And the only thing other point I'd make is I should have said investigation or other enforcement action rather than just investigation in terms of the wording. But that's just my reasons for proposing this.
I think you're muted.
Oh, sorry, Jordan, do you want to respond to the proposed change as a starting point and then opening up to the rest of the committee?
So I think most of these recommendations in A through however far this goes were based on my study of existing manuals and sort of taking best practices from what I saw in existing manuals. So all I can really speak to is that I didn't see that included, which is why it wasn't in the sort of initial list, but that certainly doesn't mean that it shouldn't be. We can also, advise agencies on matters of best practices that maybe, aren't in the data set that I worked with. So that's really all that I can say from, my report.
Thank you, Jordan. Any other committee members that have thoughts or feedback on the proposed amendment to what was originally 2B, but now might be 2C. Okay, if there are no objections to the new proposed language, we will add it to the tentative report and discuss it further after further thought in the next meeting. Okay, so let's now move over to so are there any other comments on the original 2C, which might now be 2B? I think we've fleshed out that argument, but I want to make sure before moving on to D that there aren't any other thoughts or suggestions on that. And that is now the clause, or the clause that says describing the manual's purpose, scope, organization, legal effect, and the extent to which the enforcement manual's contents may be relied upon. Yes, Kevin, sorry.
Yes, sir. I guess I just wanted to say I'll be interested to see what the language that's inserted there. I still am a little bit troubled by the idea that in addition to specifying its legal effect, there will be a specification of the extent to which the manual's contents may be relied upon. I think that that's a hard question, which is it's there in part to be relied upon. We know that, right? Even if it doesn't have binding legal effect. I mean, that's kind of so I kind of worry about how an agency would manage that question, right? If they say it's there to be relied upon, in what sense? Practical effects, it gets into a bunch of things. So I guess I'm saying maybe once we see the revision, I might object to it. I have some concerns I'm just raising now.
Okay.
But maybe we can deal with that next meeting.
Okay. Thank you, Kevin. Constantine.
I just want to share my agreement with Kevin on that phrase. I wasn't sure practically how an agency would implement that. So again, just another voice of concern on that language. Thanks, Kevin.
Okay, thank you. So let's work on that language. I think, again, we're going to look at the 2017 5 manual to see if it provides us with any guidance. And that allows to clarify. Jordan, sorry, yes.
So I was going to say the draft report tried to be careful and stipulating when we were talking about reliance in terms of internal administrative law, so standards that are binding on the agency only because of internal procedures, and standards which are sort of imposed on the agency judicially in court. So maybe when we ultimately revise this, we could keep in mind sort of, external versus internal binding effect to make that clearer.
Got it. Thank you, Jordan. Okay, so I'm going to start to describe the provision in accordance with the letters that are on the screen, so not to confuse anything. So we're going to turn to what's on the screen as 1C to see if there are any comments on 1C as listed here. And I assume, Jordan, that's an old hand, not a new one.
Sorry.
Okay, good. I just want to make sure I don't want to miss you. Okay, without any comments, we'll move on to 1D. Any thoughts or comments on 1D? Or 2D, excuse me, 2D. Okay. Okay, moving on to 2E. Yes, Kevin.
Yeah, this is really a stylistic and maybe consistency point, which is 2E has an any. It says describe any procedures, and also 2F also says any procedures. I propose striking both any's to make them consistent with the rest of them, which is, for instance, 2G says describe procedures. You could imagine inserting an any there, but I think it's better without the any in both of them.
Yep. Thank you for catching that. Any objections to that suggested revision? Okay. Any other comments on 2E? Okay. And now 2F. Any comments or suggestions on 2F? Yes, Tom.
So this may sort of be included within the concept, but I think one area where there's often a lack of transparency for regulated parties is how enforcement authorities within an agency assess penalties or choose or how the extent to which they'll recommend penalties within a particular statutory range. They often have criteria that are similar to what we might think of as sentencing guidelines, but there's often a lot of sort of uncertainty and arbitrariness as to how that process plays out. So I thought this was an area where you might make an edit such as to classify the severity of alleged violations, recommend or assess penalties or other remedies, comma, and then the remainder of it.
Jordan, do you have any thoughts in response to Tom's proposed amendment?
Not on the language so much, but I think the general idea might make sense. As a matter of best practices, I think a lot of the agencies did use either hypothetical situations or examples from actual cases that they had processed in the past in order to sort of provide some rough guidelines for how the sentencing guides were applied in specific cases. And that's something that the agencies in my interviews stressed seemed to be very, very important to regulated entities, that, okay, we had a fact pattern exactly like yours, and this is what we did in that. So something like that might make sense in the recommendation.
Okay. Any other thoughts on the proposed amendment to 2F, or any broader comments on 2F as a whole? All right, so we will work with those revisions and update 2F for the next draft. 2G, any comments or suggestions with respect to 2G? Okay, 2H. Okay, 2I. Okay, 2J. To K. Yes, Constantine.
Yeah, I'm sorry, you moved a little quickly. I want to
I'm
go
sorry.
back. That's
I'm
okay.
sorry.
The
I'm sorry.
where addressing when and how agency personnel may publicly disclose information. I just wasn't sure. I defer to others. Is there any concern about here? I may not need to worry about it because we're talking about publicly disclosing information, but situations with whistleblowers or folks going outside the agency process to disclose concerns about an enforcement proceeding. When I read this, that's why I was hesitating, because we sort of have in there, publicly disclosing information, cabinet within sort of like a press release. I just was a little worried though, if there may be concerns about people saying, I legitimately want to disclose this publicly, in another area, through other means. So I'm thinking about protecting whistleblowers here. So I'm just throwing that out to see if other folks have thoughts. Sure. And you don't have to be so Berchel formal. My first name is actually Peter.
Oh, Peter, I'm sorry, Peter.
Yeah, no worries. No worries. Not a big deal.
Okay. Okay, and so Peter, kind of coming back to you before you move on, would that be a suggestion to remove the example of press release, so that the thought is that that's not sort of perhaps the primary method by which we might think about releasing or disclosing publicly?
Yeah, I'm not so worried about the phrase the press release, and I defer to other folks from agencies. Are we comfortable with this, or would there be some sort of disclaimer this does not apply to other forms of appropriate forms of public disclosure, or something along the lines, this is not intended to impact whistleblowing? Again, maybe I'm worrying about something I don't need to, so I'd be interested to hear what other folks have to say about that.
I'll turn it to you, Adam, after we work through, if anybody has anything to say in response to Peter. Any sort of responses with respect to, and we're discussing 2J, and any concerns that come up with respect to publicly disclosed information, including from Jordan in your conversations with agency personnel, whether they raised any concerns about public disclosure.
So there definitely were enforcement manuals which discussed the agency's whistleblower programs in the manual itself. So I'm wondering if it would cover Peter's concern if we added another bullet point discussing whistleblowing specifically.
I think that's a great idea. Yeah, Jordan, I'm sure you'll say it much more articulately than me, but I think somewhere that the manuals include language addressing whistleblower protections or something along that line. I think it's a great idea.
Okay. So we'll put a placeholder for a recommendation with respect to whistleblowers, without sort of going through the process of constructing it on the fly. We'll let Jordan work with the staffers to develop the best language based on the research. All right, if there are no other comments about that particular point, I'll turn to Adam.
Thanks. My comment was actually for the one higher on the list, 2I, the one that's listed as explaining procedures for handling legal protected records or information. I think that's a good inclusion. And my point is very pedantic. It's just that we might want to go one step further, because this 2I sort of presumes that materials are legally protected. And what we might want to add is something at the end saying, I guess maybe the best way to put it would be explaining procedures for handling legally protected records or information, comma, or determining whether information is subject to any such protections. Just by way of background, I mean, when I was in private practice, often I was submitting material to agencies that was subject to protections. And then again, sometimes I was on the FOIA side of things trying to get information out of the agencies.
Right.
So it might be worth just having that kind of preliminary item in there too.
Great, great. Jordan, do you have any response to that suggestion?
I have sort of no criticism. No, I think it's, I'm wondering if there are situations from my sort of study of manuals where the agency discusses handling information that is not specifically, or is not sort of very clearly legally protected, where it's, you know, dealing with confidential information or information the agency has that is sensitive but not necessarily legally protected. So I think Adam's recommendation sort of partially deals with that issue and might be, you know, a good addition.
Okay. Thanks, Jordan. Bill.
Picking up on Adam's point, I just think would be more logical to deal with to say explaining procedures for determining whether records or information are legally protected, and then comma, and procedures for handling such information, such information or records.
Okay. Did you catch that, Alexandra, or could you do you need Bill to repeat some of those?
No, it's just flipping the two concepts. First, you determine whether they're protected, and then you decide how to protect them.
Okay.
Right, procedures for determining if such materials are legally protected?
No, and procedures for handling
Got it,
such.
thank you.
Okay.
Such records or information.
Okay.
Thank you very much.
Mhm.
I guess I'll first start with Adam, whether the friendly amendment is consistent with your feedback on that.
Yeah, it's always good to put the horse in front of the cart.
Okay.
Bill's right.
Okay. And Jordan, do you have any additional thoughts on the amendment?
No, I endorse the change.
Okay. All right. Anyone else have any objections? Or any objection? Okay. All right. So let me slow it down. So let me kind of go back. So 2I, any other comments on 2I? And then to 2J, Peter had a comment that we addressed by potentially adding a 2K, focusing on whistleblowers. Okay. 2L, any comments on 2L? Okay. And any comments on 2M? Yes, Kevin.
Just like to hear a little more about what would be included. So it's 2M is describing criteria and procedures for formally initiating adjudicative proceedings. Would that include how the agency makes choices about which forum to proceed, or is it more kind of mechanical, the procedures they formally go through before proceeding in one form or another? I wasn't sure about the scope.
Jordan, you have any response on the scope?
So my report addressed both issues. So both deciding whether the agency should, move to adjudication based on a certain level of information, evidence they've uncovered, and sort of, what that should look like in terms of if they have discretion on proceeding for an ALJ or another forum. So ACA staff can speak to the recommendation itself more fully, but my report definitely covered both issues.
Yeah, I think it was drafted broadly to include both issues.
My hand's still up. Is that okay? Yeah. I had maybe a question, which would we want to be more explicit? Describing criteria and procedures for formally and selection between the various fora, something that would have a kind of, that would add the idea of criteria for selection. I think that's is that worth being described? Criteria for selection, criteria for choice between formally initiating adjudicative or judicial proceedings and procedures. My drafting on the fly is not doing very well at all, but you get the idea that something about the selection. It really is criteria for selection, I think.
So describing criteria and procedures for selection, or just criteria for selection?
Criteria and procedure. In fact, it seems a little awkward. Maybe I'll put my hand down. I'll mute myself and someone else have a good idea.
Okay, so we're working on sort of amendments to 2M. Michael.
I just wonder whether here it's a mistake to start listing possible enforcement actions, because it's a much longer list than this. I mean, it might be a warning letter. It might be a private meeting. It might be a ticket with a minimal fine and no procedures. And whether just one wants to state more generally describing criteria for the selection among all enforcement alternatives or something like that.
Okay. Emily.
So I'm wondering if because I viewed M as being about formal adjudicative or judicial proceedings, and it strikes me that it seems appropriate to list that separately, right? There might be other informal ways of resolving the dispute, but maybe those informal ways would be better put in with the discussion in the prior paragraph, for example, on negotiating settlements. For informally adjudicating or negotiating settlements, something to that effect. Because I do think it's a different sort of ballgame when you're talking about initiating formal proceedings.
Right.
And then in paragraph M, well, I think we've gotten to where I was going to suggest we head, which was sort of talking about criteria for selection first and procedures second.
Okay. Michael.
Totally fine with me, but if you're going to do that, then I think you at least add to M the possibility of a criminal referral to DOJ. Because that's a third entry in that category of formal adjudications.
Is that what was meant by prosecuting cases? I mean, I agree.
Oh.
Mike, I think Michael's point is well taken.
Yeah.
It's not how I read it, but maybe it was. Yeah.
Jordan.
So I think Emily's suggestion makes sense, and that the universe of L and M taken together is supposed to be about procedures and about guidelines and enforcement manuals for first deciding what kind of remedial action to take based on sort of the evidence uncovered. Are we going to take a formal adjudication? Are we going to do something sort of less severe? And then M might, so L might discuss sort of the criteria for identifying what to do, and then M discuss the actual procedures that the agency has to take in order to move things along.
I guess going back to your point, Michael, you said prosecuting cases is not clear. Is there an amendment that?
Well, one of the reasons it's not clear is that the agency doesn't prosecute, DOJ does. So all the agency can do is refer to DOJ for prosecution.
Okay.
So this looks like something the agency does. So I read prosecuting cases in the kind of generic sense of pursuing a case.
Okay. So would you suggest formally initiating adjudicative or judicial proceedings and referring
And or making a criminal referral.
and or making a criminal referral? Okay.
Again, not every violation is a potential criminal violation either, but you know, it's out there for some agencies some of the time.
Got it. Any thoughts on that amendment by Michael or the prior amendments by Emily? Okay. So we have the foundation for changes that the committee will make with respect, or the staff will make with respect to those two recommendations. Okay, so that's all for 2. Are there any other comments or suggestions with respect to any part of 2 that I passed by too quickly that anyone wants to make, or that may have come up in light of the amendments to other parts of part 2 or recommendation 2? Okay, so then let's move on to the 3rd recommendation. Are there any comments on recommendation number 3? Seems straightforward. Okay, now we're moving on to the next section on managing enforcement manuals. Any comments or suggestions with respect to recommendation number 4? Yes, Kevin.
We need to say reflect current, this is in the first sentence of reflect current policies and I don't know, and law. I was worried, like, once we refer to whistleblower regimes above, right, that's not just a matter of current policy for the agency, that's going to be evolving judicial doctrine and everything. So there's a kind of broader, unless it could be in the next sentence and I haven't gotten there, but whether there's a kind of current policy, we want them to update them generally, including as to current policy. They reflect current policy. So I'm just trying to, I don't know if this is the best place to register that thought, but it seems like a possibly a logical one.
Right. Okay. Any thoughts on that amendment, Jordan?
I think it makes sense. I mean, there are definitely scenarios where agencies let their enforcement manuals get a bit behind legal changes, either statutory or in the case law. So it might make sense to clarify that as suggested.
Yeah.
I put law before policies.
Law before policies. Okay. All right. So I'll reserve my comments in terms of with respect to the capacity to update and what that might mean for disseminating enforcement manuals to the next section. But are there other comments on the fourth recommendation? Okay, so let's move to recommendation number 5. And I guess we'll just treat this as a whole rather than going through A, B, and C. Yes, Michael.
Very minor, but I tripped over. The first sentence says agencies should develop procedures, and the next says these policies. I think we should either say procedures or policies, not switch
Okay.
from one to the other.
Got it.
Is there a preference for one or the other?
Yeah. Jordan, what do you think in terms of, or Jeremy, with respect to from the staff angle? Whether it should say procedures or policies, whether it should be
I think it's procedures for what it's worth.
Sorry, I'm still reading along.
Yep. So we'll try that out and see how that sticks.
I think your procedures might work better. Yes.
Okay. Any other comments or suggestions with respect to recommendation number 5? Yes, Emily.
This is a minor point, but in subsection A, it might read a little easier if it said how often the enforcement manual, comma, in whole or in part are reviewed or is reviewed.
Mm-hmm. Okay.
That would take out individual sections.
Yeah, take out individual section
Yeah.
and change R to is how can the enforcement officer in whole or part is reviewed. Okay. Seems to read a bit better. Any thoughts on that amendment? Or objections to it? Yes, Michael.
Oh, just one more trivial thing. The and belongs at the end of B, not at the end of A.
Right. Yep. Thank you. Good catch.
And you might make a conforming amendment in B.
Okay, right. In whole or in part. And then taking out or individual sections or reviewing in individual sections. Okay. Any other thoughts? I guess we would keep the colon right after part, I think, or is that still there? That's still there. Okay. Any other thoughts or suggestions? Okay. So I guess we're ready to move on to recommendation number 6. In the third part, disseminating enforcement manuals. So the first recommendation number 6, are there any comments or suggestions? Yes, Bill.
It seemed to say that you shouldn't get it in paper.
Right.
And I mean, I'm still a paper person, maybe some other people are too. I mean, it seems to me this should be in addition to on paper in some way, but that's the way it reads now. I read it as saying, this is the only way you do it.
Right. Peter, so we could, I guess before, is Peter, is this directly responsive to Bill's comment?
No, it's not. So
Okay, so in terms of, I'll come to you, Peter, in 1 second.
sure.
So thinking about sort of what the change in language would be, should make enforcement manuals available on
So before
paper or through a searchable electronic format. I'm sorry, I cut somebody off.
You
Sorry,
could say- You could say should at least,
Should at least, okay,
then that would make clear that other forms would be possible as well.
got it. And Jordan, you had something to say? And
sorry, it took me a while to figure out the hand raise feature. So I guess before we decide what to do with this, just as sort of a background, I wanted to speak to what I think this is doing in the recommendation, in that as a matter of best practices, there are a lot of agencies like the IRS Internal Revenue Manual that has an online version of the manual that has a lot of metadata involved in terms of who's responsible for doing what. That's very useful, that really can't be included into a print manual. And also situations in which, well, most of the time it's easier to keep the electronic edition up to date. So rather than printing a whole new copy of the manual every few weeks or every few months. So I think what we were trying to do with this part is say that there's sort of a matter of best practices in which you can keep an electronic version of the manual that can do things that a print edition cannot.
Right.
So if you want to add something to address Bill's comments, just to keep in mind sort of the purpose this is here in the first.
Right. Thank you, Jordan. So it seems like at least wouldn't disrupt the purpose that you're with respect to this section, because it's still pointing to the importance of keeping an electronic format, which is much more easily revisable and searchable as well. But it gives agencies the options or suggests alternative ways of keeping the information if they have the capacity to do so. Is that a right assessment, Jordan, or do you think they at least might be contrary to purpose?
And to be clear, I'm not trying to dismiss Bill's comment. It's just like that would be, I think, a separate section if we wanted to address that.
Okay.
Well, I thought that by putting at least in there makes this at least means this is the electronic is the preferred thing. But if you want to do more, then you can do more. So
Right.
I think that captures Jordan's point.
Yeah. Okay. Any other thoughts on Peter's comment before, or Bill's comment before I turn to Peter? Okay. Peter.
Yeah, I'm just mindful of the executive order on equity and accessibility, and I'm wondering if we should include language either in 6. I'm more mindful of 6 or 7, language that agencies should give particular consideration to making manuals accessible to traditionally underrepresented groups or populations.
Okay. And that way, yeah, okay, great.
I think it could follow on as part of 6.
Part of 6.
I'm sorry,
okay.
not found, but yeah, it'd be part of 6, excuse me.
Okay. So next sentence.
Agencies should give particular consideration to ensuring that manuals are accessible to traditionally underrepresented populations or groups, whatever the best wording is there.
Represented. And we could sort of decide between groups or population,
Right.
based on what other manuals have said,
Mhm.
to be consistent with that language. Okay. Okay, great. Thank you, Peter. Any comments on or objections to Peter's amendment?
Yeah, I think it should go in 7, not in 6, because 6 is all about what is how you have the enforcement manual, and 7 is about making it available to the public. And so I think, I think it makes more sense in 7.
Okay, thoughts on that, Peter?
Yeah, I think it go either way. So 7 is perfectly fine too.
Okay. Yeah, I agree. I think it does fit a bit better in 7 as well. Bill, is that a hand down? Okay. Any other comments on 6 before we move on to 7? All right. So comments on 7, including Peter's amendment to 7. I guess one question I had with respect to if an agency doesn't have the resources to keep manuals up to date, should they produce enforcement or should they produce and disseminate enforcement manuals at all? And the story that I have is of the FTC having a 1971 enforcement manual and keeping it around and realizing that's completely out of date. So they're just, get rid of it altogether as identified in your report. And it's kind of a cautionary tale about sort of keeping enforcement manuals at all when you can't keep them up to date. I just want to get Jordan's thoughts and reactions to that concern.
So if you're speaking to the distinction between if you have a manual that's out of date, keeping it internal versus making it publicly available, I think what I had in mind in the report is if the manual is out of date, like the FTC manual was, FTC officials have a much better idea of what supplemental guidance documents have been issued to modify the manual and the general public can. So the potential to mislead the general public is much greater. While if it's just intra-agency, everyone in the enforcement division will presumably know that there are these 3 important guidance documents that substantially modify what's in the manual. So when I spoke to FTC staff, they said that they still use the manual for some purposes, even though they knew that it was badly out of date and could mislead the public, because there are certain things such as the way it handled confidential information that were still very useful as a form of internal guidance. So I think your concern is an important one, but just sort of what I had in mind when I was drafting.
Yeah, that's a very helpful clarification. So there's value in terms of keeping the agency manual for internal use, but being much more cautious about disseminating, especially if you have the capacity to update the manual because it might mislead the public. Thanks. Bill.
I would say agencies should make entire or portions of enforcement manuals publicly available. We recognize that there are aspects of enforcement manuals that we don't want to be made public and shouldn't be made public, but I don't want to make it sort of an all or nothing type of thing. Okay.
Yeah, that's a good point. In your experience, in terms of your research, are there examples, Jordan, of agencies making manuals partially available, trying to avoid circumvention of the law through information that might be released through enforcement manuals? You mentioned that there have been some cases in which information has been redacted in enforcement manuals, if I'm remembering correctly from your report. What are your thoughts?
So I think there are 2 ways that agencies might handle that. One is to, like the Internal Revenue Manual from the IRS has a lot of things that are just redacted, that you can look at the entire Internal Revenue Manual on the internet as a member of the public, but there are things that are going to be explicitly redacted, like a confidential document that you get from the government or something. The other thing that they can do is they can have 2 different manuals, one manual that contains the stuff that's fit for public consumption and one that's just, policies and procedures for things like how do we detect violations that should not be made public. And my report wanted to be sensitive that some agencies find one of those alternatives superior to the other and to leave it sort of the agency discretion based on their own situation.
Okay. And so that amendment or portions thereof would be considered a friendly amendment that would be consistent with your report, Jordan?
Yes.
Okay. Yes, David.
Section 6 addresses helping agency personnel. Section 7 addresses disclosure to the public. For that reason, I would suggest at the end of 6, deleting or public website. If your objective, as is the purpose of 6, is to inform your staff, I presume you wouldn't do that on the public side.
Got it. Jordan, your thoughts on that, or Jeremy?
I was having trouble hearing you.
Oh, so David made the point that we should remove the public website, the last 2 words of recommendation 6, to the extent that.
Thank you so much.
Yeah, that recommendation is directed towards enforcement personnel rather than the public. Is that a proper characterization of recommendation 6, first of all? And do you agree with that amendment, secondly? And I'll start with either Jordan and then move to Jeremy if he has comments.
My initial thought is that this makes sense in that I don't know of an example where the agency sort of promulgates its, hot off the presses changes to the manual directly on the public website as opposed to putting it on the public intranet or something like that. So I think my initial impression is this makes sense.
Okay. Any thoughts from Jeremy or others?
I'll defer to Jordan on that one.
Okay. All right, so we will, without objections, we will remove the language or public website from recommendation 6. And then with respect to recommendation 7, Bill suggested amendment or portions thereof. Are there any comments or suggestion with respect to that amendment or any other aspects of section or recommendation 7? Michael.
So
is that old hand, David? I'm sorry. Is that a new hand or old hand, David Pritzker? Okay, thank you. Okay, Michael.
So a kind of general comment and a specific comment. The very specific comment is, I'm not sure about this phrase, improve public awareness of and compliance with relevant policies. I mean, really, we're talking about compliance with the law. I mean, that's what's being enforced, our legal requirements. And the reason, and that's the ultimate goal here, is to enable, enhance, and improve compliance with legal requirements. I'm not sure what the relevant policies are.
Okay. So the amendment to relevant policies, is there a thought process or a reason why we would keep relevant policies as opposed to changing it to legal requirements? I'll start with you, Jordan.
I think we might want to include both insofar as in the report, I saw the primary value of enforcement manuals as opposed to other forms of guidance being to inform the agency to inform the public of the agency's exercise of discretion. So insofar as the enforcement manual sets out policies for how the agency is going to exercise its discretion when it could, act in a number of ways. So I would probably have policies and legal requirements instead of just dropping policies.
Okay.
But are regulated entities complying with the policies?
I think,
Okay, I take your
Michael,
point.
would you be comfortable with public awareness of relevant policies and legal requirements and compliance with legal requirements?
So public awareness of relevant policies and compliance with legal requirements would be the suggested amendment from Jeremy. Would that satisfy your concerns, Michael?
Yeah, I think that works. I mean, subject to the committee on style, but yes. I think that
Right. Okay.
The broader comment is this, and it's somewhat unformed. So one of the reasons I'm here is, as some of you know, I'm a member of a consultants group for a separate project on the availability of agency legal materials, right, which is a sweeping term, but it would include enforcement manuals. And we're not as far along as this project is, and this is one of many ACUS projects, recent and distant, that overlaps with ours. And one of the things that we're doing in general is keeping our eye on the other ACUS projects and incorporating, or at least trying to be consistent with prior recommendations and so on. And there's nothing here that's fundamentally inconsistent with anything we've been saying or talking about. I would say our instincts, our tendencies, our priors as a group are a little more pro-disclosure than this one feels. And the question is whether in the preamble or here or somewhere, the committee wants to just put a little more thumb on the scale, endorsing the benefits of disclosure, right? So that's a broader question. It's not specifically about the wording of 7, but it's about this whole section on dissemination. The tiny thing I would change that I would suggest that's along those lines is changing in line 95, if to when, right? Publicly available when doing so, right? Which kind of confirms this is real. It's not hypothetical. It's not, well, conceivably at some point it will be, but there is a category where really it is worth putting these up and you should do it. Okay. So that's the only really concrete proposal I'm making in terms of the larger thing, but I throw it out for this committee's consideration.
Okay. So that would be kind of a slight change in the language that would put small part weight of the thumb on the scale in favor of disclosure?
To me, it's just a tiny nudge in the, and
Right.
an appropriate one in the
Okay.
direction of
Okay.
even a presumption of disclosure is too strong a term, but.
Right. And so we'll return to the broader point that you're making when we get to our preface after working through the recommendations, but I will keep that in mind as a starting point for addressing the language of the preface in terms of whether we want to put the thumb on the scale in favor of disclosure or not in this report. Thank you, Michael.
Thank you.
Any other comments on recommendation number 7 or any feedback or thoughts or reactions to Michael's proposed amendment shifting if to when? I guess I'll start with Jordan.
I have no complaints about the change.
Okay. Anyone else have reactions or thoughts to the change or more broadly to recommendation number 7? Okay, then we'll move on to recommendation number 8. Thoughts, suggestions, or feedback? Is that an old hand, Michael, or is that a new one?
It's a new hand.
Okay, Michael.
Maybe just eliminate, take steps to, agencies should provide notice.
Okay, got it. So removes ambiguity as to what those steps might be. So any reaction to the change? Jordan, is that with that?
Yeah, I have no complaint. No.
Okay. Bill?
Well, I taking the opposite side of Michael's making everything pro-disclosure. It would seem to me that it should be agency should provide notice to the public when they issue or revise a publicly available enforcement manual.
Okay. All right. All right. Okay. So that's consistent with the prior recommendations. Any comments or objections to that language? Added to recommendation 8. Any other thoughts on recommendation 8? All right. So let's move on to recommendation number 9. Thoughts, suggestions, or reactions to recommendation number 9? Okay. So now to the final section of the recommendations, which is on soliciting input on enforcement manuals. And we'll start with recommendation number 10 to see if there are any thoughts, suggestions, or feedback. And finally, to recommendation number 11. All right. And so before moving on to the preface, I want to make sure that everyone's comments have been addressed on any of the recommendations. So I'll open it up to all the recommendations. Yes, David.
I suggest on line 105, drop the S at the end of reflects.
What was that again, David? I didn't quite catch
Line
that.
105.
Okay.
Change reflects to reflect without the S.
Oh, without the S. Okay, so taking out the S. Okay. Thank you.
One can argue for either way grammatically, but I think it reads more smoothly without the S.
Okay. Any objections to that change? Any other comments on the recommendations 1 through 11? All right, so let's scroll back up to the preface. I don't know if it's possible to get the entire preface on the screen or not. But I guess we could take it paragraph by paragraph instead. So why don't we just kind of take some time to read the first paragraph of the preface? And Michael, thoughts on where your presumption of disclosure might play in terms of the language of the preface? That would be helpful. Thanks, Bill. Would be helpful. So just chime in when you think that there could be changes in language or addition of language, and see what other people think about not presumption of disclosure, but thumb on the scale of disclosure idea. Any thoughts on the first paragraph of the preface or preamble? It's preamble, right? Not preface. Preamble. Guess I'll call them both. Okay, we'll move to the second paragraph, but please feel free to raise comments on the first paragraph if they come to mind. Any thoughts or suggestions with respect to the second paragraph? Okay, the opportunity will remain open to comment on the second paragraph, but for now we'll kind of scroll down so that we can all read the third paragraph in its entirety, I hope, yes. So this may be relevant to Michael's point, this paragraph with respect to the thumb on the scale of disclosure. I'm wondering if it's this particular paragraph that raises concerns, his concerns about where the weight of disclosure and withholding lie. Not to say that we should favor necessarily one or the other, but I was wondering if this was the paragraph that from which his perception that this is a document that is not as favorable to disclosure as a report that he's consulting on right now.
Well, a couple of little things that might go in here, for example. One is there's the compliance with relevant policies point recurs here, but that's a separate thing. It's of so I mean, one of the things we made the decision to do was not to revisit FOIA exemptions, right? Take the FOIA exemptions as a given, right? And not sort of go out there and say, okay, we got to amend 552B. And that was sort of beyond the scope and too big a thing. And this report takes the same approach, and I think that makes sense. One might say, and here's where they're acknowledged and they're totally legit. One might point out here that, you know, that agencies are free in their discretion to release exempt materials. And this doesn't say that. Indeed, under the 2016, there's always been this back and forth about the presumption of disclosure or not the presumption of disclosure under FOIA, but it got written into the law in 2016. Either proactively or not proactively for that matter, right? But that the exemptions allow but don't require. I mean, the privacy exemptions require, but as a general statement, most of the exemptions allow but do not require withholding. The other thing is, I think for a lot of this, maybe less enforcement manuals than some other things, but also enforcement manuals, they're useful not just to directly regulated entities, but they're useful to regulatory beneficiaries. They're useful to citizens who care about public policy. They're useful to watchdog groups that want to know how agencies are spending their time and taxpayer dollars. This is written with at least an implicit focus on just, if you have to comply, if you're directly regulated, these will be handy, though maybe a little too handy, so we got to be careful. And that's sort of, I think there's a larger audience for these, as for many agency legal materials, beyond just directly regulated entities, and that might be made express here.
Yeah, my sense from your report, Jordan, is that you were focusing on multiple audiences here. You spoke about specialized bar. You also spoke about, the broader public as well, and non-specialized groups. And there does seem to be a concern about using manuals to circumvent the law, for sure, that I think is reflected in your report. But what are your thoughts in response to Michael's comments in terms of the balance or the, how we're weighing disclosure versus withholding in light of the multiple audiences?
So on the issue of keeping in mind the multiple audiences, I fully agree. And if there were specific language that he thought we should address, I would be interested in hearing that. In his overall sort of general comment, he is right that I tried to be very sort of cautious in writing this report, insofar as I did speak directly with agencies who had made what they believed to be very carefully considered decisions not to disclose. And the report was written with the lens of not sort of stepping on the toes of the discretion of these agencies. But it's up to the committee whether it wants to be sort of more ambitious than the current language reflects.
What do committee members think in terms of, in response to Michael's comment and Jordan's reaction about how, I don't want to say prescriptive, but how encouraging we might want to be with respect to disclosure? Yes, Miriam.
I find myself agreeing with the comments that these documents are very helpful to more than just the regulated parties. As an agency that doesn't really do enforcement, but that sees a lot of regulations, our mission, the Office of the Federal Register, we publish on behalf of the federal agencies. And so there are clients, if you will, but everybody else is our customer. That's how we've set up, and that's why we've normalized Federal Register documents, put in the categories, required the preamble captions, set up the CFR so that all the titles look the same, no matter what agency is publishing. For the most part, whatever title you go into, it's going to be organized the same way, whatever the content is, so that even if you're a non-expert, you can go in and you can figure out where you are and you can find things. So there are a lot of people who are interested in what the regulated parties are doing, are supposed to be doing, who want that information for a wide variety of reasons. And I think disclosure we need to be looking at them just as much as strictly for the people who are going to be using it because they're going to be directly affected because this is how they're supposed to act or how they'll be in trouble if they don't act a certain way. So I think adding the line agencies may proactively disclose material exempt under FOIA is a good start. I don't have any really concrete language recommendations right now. Unfortunately, I'm in LA on travel and I didn't have time to really go through this before this meeting. But I think we need to make our focus a little bit more broad. In encouraging disclosure. So I agree with, and I forget who it was that was speaking that I agreed mostly with, and now I can't find his picture or his name. I'm sorry. I can scroll through, let's see. Michael, there's Michael.
He's waving
Yes.
at you.
Yes, he is, but we've got I've got like 5 screens of people, so I had to scroll through to find him waving. So yes, so yeah, I agree with a lot of what Michael was saying about disclosure and being more pro-disclosure than less disclosure. I mean, there are parts of enforcement documents that we do not want to disclose, but those are the exception rather than the rule, I think is how we should approach this. Thank you.
So in terms of kind of trying to categorize the issues here, so there's a choice to create an enforcement manual, which goes to capacity and to do so, and the ability to update it. And then there's the second part with respect to disclosing an enforcement manual once made to the public, which I think the principal concern with respect to disclosing to the public or reasons for withholding would be concerns about circumvention of the law and the use of the manual to circumvent the law. I wonder, Jordan, if there are any other concerns and whether those concerns can be addressed in full through a proposed through a proposal that encourages disclosure with the idea that they can always redact the information that the agency finds would be at risk of being used for circumvention purposes. Jordan.
So the track I try to take in the report itself is I do try to recognize the diversity of interest. So one thing that came up in my interview with the Nuclear Regulatory Commission officials from there was that they find it very important to solicit feedback from Native American tribes who are in the vicinity of nuclear facilities about sort of how that will affect tribal lands. And you have this kind of thing throughout the regulatory state, what you might call sort of indirect beneficiaries of regulation. And the track my report tried to take is that this is sort of a subject of cost benefit analysis, and that it's very important for the agency to take into account what these sort of spillover effects on groups that it might not, initially have in mind are. In terms of, I'm curious as to sort of what parts of the recommendation, either the preamble or, otherwise, would need to be changed to be more sensitive to these concerns.
We have one suggested line at the end of paragraph 3, agencies may proactively disclose materials exempt from under FOIA. Miriam says that's a good start. But what else might we add? Michael?
So it's a totally fair question, and you began our turn to this preamble with your totally fair nudge to me to come up with some language as we went along. And I realize I've fallen down on that job. It's partly because like Miriam, though I'm not in snowy LA the way she is. I have not focused on this as much as I should have, for which I apologize. It's my fault. But what I would suggest, and you know, and drafting on the fly is always risky.
Sure.
What I would suggest, I know there's at least one more meeting of this committee on this proposal, right? In a few weeks. Between now and then, I speak to some of my colleagues on our group. Okay, and we talk among ourselves, and if there's particular language we can come up with that we think would be really helpful, we'll circulate it well in advance of the meeting. And if there's not, we'll let you know that. And we probably should have done that 2 weeks ago, and I apologize for that, but I think there's still time, and that might be the best way to proceed.
That's the reason why we have multiple meetings. So yes, that would be much appreciated to the extent that you can talk to your colleagues on that other report.
Great. All right. I will undertake to do that.
Thank you, Michael. David.
It strikes me that since the preceding sentences are all about what the exemptions provide, that this sentence tagged on to the end is a quick shift of gears, and to make it flow more smoothly, I would suggest putting however at the beginning and say, however, comma, agencies may proactively choose to disclose materials.
Yeah, I think it's absolutely right. Okay, so this language that we have here is very tentative. We're gonna have Michael discuss with this group any thoughts on other language, but this could at least give us a starting point for revising the preamble, or at least this part of the preamble. Okay. Any other comments on paragraph 3 of the preamble or broader points about disclosure versus withholding? All right. And is there one other paragraph here in the preamble, or is that just, we'll just kind of, I'll just ask other thoughts on this last paragraph of the preamble.
I left my hand up because I have a comment on
Oh, yes.
this.
Okay, yes, David, thank you.
The final sentence, starting on line 33, has a syntax problem. And the problem arises at the end where it says differ among programs. My suggestion for fixing this is to have it begin as it reads, in offering these recommendations, the conference recognizes that enforcement manuals may not be appropriate for all agencies. I put a comment in there. Given differences in the volume and complexity of documents that govern their enforcement activities, resources available to agencies, and the differing, insert the word differing, information needs of persons affected by or interested in agency enforcement activities.
All right.
And end the sentence there.
Yep. So take out above programs. Yep, that makes sense. Any thoughts on David's amendment or other aspects of paragraph 4 of the preamble? Okay. Now give one more beat of the heart to see if there are any thoughts on the overall preamble as written right now. Adjustments will be made to the preamble and to the recommendations before our next meeting, but before ending, I just wanted to see if there are any overriding thoughts on the preamble that folks have. All right. Okay. Gosh, sorry, I have to pull up what am I supposed to do now? All right. Okay, I guess I'm supposed to tell you that our next meeting will be on Tuesday, November 1st, from 12 to 3 p.m. Eastern time. Before closing the meeting, I wanted to see if Chairman Foyce had any closing remarks for the committee.
Yes, thank you very much, Bertrand. And let me say, this is pretty amazing, your first time out to do 11 recommendations and a whole preamble in less than 2 hours. So we may be putting you as in as chairman of all 5 of our committees, if you can do this regularly. So thank you to you for leading us through a very methodical and thoughtful process. Thanks to all the committee members for your input. And thanks again to Alexandra, Jordan, and Jeremy for all the work they put into the recommendations and the preamble and the report. So thanks all. See you next time, and have a good rest of the afternoon.
See you all in a couple weeks. Thank you so much, Chairman.